So I have in my hands a petition to the United States Supreme Court in Jennifer Murphey versus the United States of America, the FDA, DEA, HHS, and the state of Arizona. And I am Jennifer Murphey. I'm an attorney, and I wrote this. I created a lawsuit that I filed initially in 2022. It is the biggest lawsuit in history to challenge the war on drugs. In this lawsuit, I essentially serve as prosecutor on behalf of the people. So a lot of us know that the war on drugs is wrong. We don't quite understand why or how as far as the legalities of it go. A lawsuit is a bit different than policy change. My job is to present why the Controlled Substances Act and 2 international treaties are illegal, why the entire thing is illegal. See, policy change and just fighting within the system affirms that that system is legal. This steps outside of that and says that the entire system is illegal and that what the government does is illegal. Including the United Nations, the World Health Organization, pursuant to these 2 international treaties that I talk about. So essentially what I'm saying is that the government is acting unlawfully and we need to question, and it needs to be reviewed by the court so they can determine whether the government is actually acting illegally. So that is my purpose, a prosecutor on behalf of the people pursuant to this lawsuit. If you would like to know more about how it reached the Supreme Court and the process, and if you would like to know more about the claims, I highly recommend watching the video I posted before this, where I do a detailed explanation of everything. For purposes of this, I wanted to read the petition. This petition is so important. And so far, the Federal District Court and the Ninth Circuit have ignored my lawsuits. They dismissed my claims by applying incorrect law, and I feel like they didn't even read my complaint, which was essentially a research paper of 60 years worth of illegal government action. So this is my last opportunity for all of us, is to go to the Supreme Court and ask that they review the decisions by the lower courts. So the purpose of the petition is to present to the court of why they should hear the case. I'm not asking them to decide whether the claims have merit or not at this point in time. And if they do grant review, then we will go into oral arguments and briefing, and then they will decide whether the courts decided incorrectly or not. And so as I'm reading it, the first part that I'm going to skip a few parts that are probably going to bore everybody. You are welcome to read the petition and everything else I've written on my website, decrimOurminds.com. But the first part of the petition is the statement of facts. And so that's essentially a background, a summary of a lot of information. I'm going to describe the legislative background of the Controlled Substances Act and these 2 international treaties. And then I'm going to go into the freedom of thought implications and then the due process implications. The next part is the reasons why the court should grant this petition. And I have essentially 2 reasons. The first reason is that the Ninth Circuit applied incorrect law and just decided incorrectly. And then the second reason that I'm presenting as to why the Supreme Court should grant this petition is because it is of national importance. The legality of it, whether the government is acting legally, that has never been questioned. Being that this has resulted in imprisonments and deaths of millions of people, it deserves to be questioned. The reason I would like to read this, there's a couple of reasons. For one, this lawsuit, even though it's historical and unprecedented, is not really known. And it affects all of our rights. It presents new concepts. So I believe by speaking this out loud, it will help to enhance the power of this petition. This will give it energy, and it will help millions of people. And so I believe it's important to speak it into the airwaves, so to speak. But I believe it's also equally important to have others share this perspective. So I ask that you release any beliefs you might have about the war on drugs, about what it even is, what it does, how it works, what your opinion on it is. I ask just for these next 30 minutes or so as I read this petition that you release those and be willing to expand your mind to receive a new perspective. It should be educational as far as how the Constitution works and how the justice system works. If you stay to the end, I guarantee you'll have a fire ignited within you, because the end is the most powerful, in my opinion. So with that, I'm going to read the petition. The first part is the war on drugs legislative background. In 1961, the United Nations adopted the Single Convention on Narcotic Drugs, which sets forth an evaluation and scheduling system through which the possession and distribution of specific categories of drugs are controlled. As a party to the Single Convention, the United States ratified the treaty in 1967. In 1970, while simultaneously declaring a war on drugs, Congress amended the Public Health Service Act to implement the Single Convention to carry out its obligations thereunder. Congress named the legislation the Comprehensive Drug Abuse Prevention and Control Act of 1970 before later renaming it to the Controlled Substances Act. Congress adopted the UN's drug schedules and a similar evaluation and scheduling process, while further creating criminal penalties for conduct prohibited under the convention, such as simple possession. A few months thereafter, the United States ratified the 1971 Convention on Psychotropic Substances. In 1978, Congress further amended the CSA to enact this convention into domestic law. The type of drugs subject to control under the CSA and conventions are limited to substances that affect the central nervous system, CNS drugs, and are identified as having a potential for abuse. Meaning, under these laws, the government is only concerned with controlling possession of and access to substances that have the potential to affect our internal cognitive and emotional states. Once a substance is flagged as having the potential to affect those internal states, meaning it has potential for abuse, it then undergoes an evaluation to confirm said potential and to determine placement into one of 5 schedules. Once schedule placement is determined, the government proceeds with rulemaking to update the schedules, which are housed in the Code of Federal Regulations, and rely upon said schedules for its ongoing criminal enforcement actions. The CSA provides 2 separate sets of procedures for drug evaluation and scheduling. 1, procedures for drugs not scheduled by the UN under the conventions, whereby the respondents, which is the government here, perform their own evaluation and schedule placement decisions pursuant to required findings and factors set forth in the CSA. And 2, procedures for drugs evaluated and scheduled by the United Nations pursuant to the conventions, whereby respondents simply adopt and implement those decisions into the schedules without performing independent evaluations. Once a substance is added to the schedules, simple possession thereof is then criminalized accordingly. Respondents enforce the criminal provisions of the CSA in the same manner, regardless of whether the substance was evaluated and scheduled by the United Nations, pursuant to the conventions, or by the respondents. Okay, the next part is the First Amendment freedom of thought implications. The explicit purpose of the CSA and both conventions is to prevent and combat the serious evil and immorality of drug abuse and its cognitive and emotional effects on the individual consumer. Thus, for thousands of drug evaluations over the past 60 years, the determination of how drugs will be scheduled, and thus whether mere possession thereof will be criminalized, is largely based on how a product might make us think or feel should we consume it. The United Nations, specifically the World Health Organization, and respondents have each created investigation protocols that they use for every drug evaluation to identify and presume potential cognitive and emotional states that could occur in individuals who consume the substance under evaluation. The evaluation procedures under the CSA and conventions share a common theme and define drug abuse accordingly. They both investigate, document, and define drug abuse as the thoughts, feelings, and desires an individual might have before, during, and after consuming a particular substance. Specifically, they investigate 1. Thoughts indicating individual motives for consuming a substance. 2. Thoughts, moods, and emotions that could occur upon consumption. And 3. Thoughts, feelings, and desires that might occur post-consumption. To investigate potential for abuse, the government and the World Health Organization go to extremely invasive and unlawful lengths to probe into our minds to predict our thoughts and feelings. They assign government employees to browse internet forums. They look for individual hobbies and personalities that indicate creativity. They conduct studies on animals and humans to extract and document potential cognitive and emotional processes. They investigate how much one thinks about using drugs and consider how people react to normal adverse life events. They look for indications of nonconformist thoughts and individual desires to gain introspection or expand consciousness. They further look for euphoric thoughts and feelings, as indicated by elevated mood, feeling abnormal or relaxed, and abnormal thinking. Any indication of euphoria, which is defined as extreme joy or happiness, is deemed by respondents as a key observation in determining potential for abuse. Their investigations into and findings of potential cognitive and emotional states encompass most of the drug evaluation process and serve as the primary basis for the determination of whether the harmless conduct of mere possession will be criminalized. The government attempts to evade constitutional scrutiny by alleging that because they only criminalize conduct, the First Amendment's prohibition of government intrusion into our minds is inapplicable. However, such conduct of merely holding in one's hand a pill or plant is harmless, and nowhere in the thousands of drug scheduling records does the government claim otherwise. Nor does the government claim that the act of consuming a product such as inhaling smoke or swallowing a pill is harmful. So why does the government criminalize such harmless conduct, and why are people being imprisoned by the millions and branded criminals for such harmless private conduct? The answer, to prevent and combat drug abuse, is explicitly stated in the text of the CSA and conventions and is directly evidenced through thousands of drug evaluations and scheduling decisions. Drug abuse is not defined by conduct or acts. Drug abuse is defined as specific cognitive and emotional states that could occur internally should we consume the substance in our possession. And potential for abuse refers to the likelihood those internal states could be experienced by consumers. Thus, the criminalization of mere private possession of a controlled substance is based almost entirely on the government's explicit desire to prevent certain internal thoughts and feelings it identifies as unfavorable or as a serious evil. Okay, the next part is the procedural due process implications. Interestingly, the government deviates from its declared purpose of preventing and combating specific cognitive and emotional states when it evaluates and schedules drugs from pharmaceutical companies. For pharmaceutical drugs, the evaluation and scheduling process is delegated to the FDA, who further delegates the abuse potential assessment to the pharmaceutical companies themselves. The DEA is then bound in many regards by the FDA's drug evaluations when determining schedule placement. This raises significant procedural due process concerns, considering the FDA's drug division is 75% funded by the pharmaceutical companies whose drugs it evaluates and recommends for schedule placement. Consequently, with a direct financial interest in approving drug applications submitted by its funders, the FDA approves those applications approximately 90% of the time. And with a direct financial interest in recommending schedule placement, allowing for the legal distribution of pharmaceutical drugs, it makes such recommendations nearly 100% of the time. Comparing the government's evaluation and schedule placement procedures of pharmaceuticals versus non-pharmaceuticals presents a night and day difference and an extreme bias favoring its funders. In its evaluations of pharmaceuticals, the government intentionally omits or ignores hundreds of studies about the harm of CNS pharmaceuticals, including millions of instances of drug-induced disease and death, toxicity, high addiction rates, and fatal withdrawals. Further, in its schedule placement decisions, the government explicitly disregards and biasly applies the findings and factors that are statutorily required under the CSA. And in doing so, the government falsely declares that these drugs are safe for use and are less harmful than drugs on more restrictive schedules. Moreover, both the UN, pursuant to the conventions, and respondents use decades-old information. They fail to consider new evidence of harm and consistently fail to provide any rationale or meaningful nexus tying drug evaluations to ultimate schedule placement decisions for both pharmaceuticals and non-pharmaceuticals alike. Further, the conventions are devoid of any required findings, descriptions, standards, or anything else that guide or justify schedule placement decisions, thereby providing the UN entities full discretion with no accountability and no required rationale for its schedule placement decisions. Thus, unlike non-pharmaceuticals, the government makes an exception for pharmaceuticals with regard to the CSA's alleged purpose of preventing drug abuse or otherwise protecting public health. This has resulted in the mass marketing and drugging of the population with deadly, toxic, highly addictive drugs that are known to numb the mind and emotions of consumers. And these are permitted to be marketed and legally distributed through inadequate and unconstitutional procedures, all to the direct financial benefit of the respondents. The respondents have effectively created a monopoly on mental health care, whereby consumers are limited to choosing pharmaceutical products that are often more harmful than non-pharmaceuticals or otherwise face criminal consequences. Accordingly, respondents are directly responsible for the implementation and enforcement of unprecedented criminal legislation that punishes consumers and imprisons millions of humans for the harmless act of choosing and simply possessing non-FDA approved products. Okay, so that is the background. Those are the summary of the facts. And now I'll go into the reasons that the Supreme Court should grant this petition. This part should be a little more exciting. For over 55 years, the legislation implementing the so-called war on drugs has endured unchecked and unquestioned. It has led to millions of deaths, disease, broken spirits, and families, and has caused the U.S. to be the top incarcerator in the world. Its impact on this country, society, and the human spirit is catastrophic. Through hundreds of hours of research and analysis, I learned the processes used by the government and the UN to evaluate and schedule drugs. What I discovered raised significant and valid concerns that this unprecedented criminal legislation has been enforced unlawfully and unconstitutionally for decades. Thus, through a 56-page complaint, I presented an unprecedented analysis of this legislation, including numerous references to government documents spanning 60 years, a thorough explanation of the procedures used under both the CSA and the conventions, and a rational nexus tying the alleged facts to claims that are firmly grounded in and supported by this court's prior decisions. Yet the lower courts dismissed all my claims and decisions that leave me questioning whether my complaint was even read. In its decision, the Ninth Circuit either ignored or deviated so far from relevant Supreme Court precedent, failed to conduct any meaningful analysis of my claims, ignored the hundreds of well-researched facts, and often wrote only one or two sentences for each claim to justify its dismissal thereof. The Ninth Circuit's insurmountable bar to justice and failure to conduct a meaningful analysis is especially grievous given the importance of this subject matter and the lives at stake. The question of whether the destruction of this 55-year alleged war is the result of unlawful government action deserves review by the courts in a lawful, just, and meaningful manner. So first we will talk about the Ninth Circuit and the Federal District Court denied me standing to challenge the two international treaties, the conventions. And because those international treaties are enforced domestically by the DEA, and because I am subject to that enforcement, then I should have a right to challenge those treaties. We all do. We have a right to challenge laws that affect us. And the lower court said that I did not. So this first part is about that. The Ninth Circuit denied me standing to challenge the conventions by creating a new rule that treaties must be self-executing to be judicially enforceable in our domestic courts. The Ninth Circuit's new rule directly conflicts with Supreme Court precedent, which provides that treaties become domestic law and challengeable in our domestic courts when Congress enacts implementing statutes. Each convention challenged was implemented by Congress through separate amendments to the CSA. The 1970 amendment was specifically designed in part to meet the United States obligations under the 1961 Single Convention. In 1978, Congress further amended the CSA to implement the 1971 Convention on Psychotropic Substances and the Schedule of Drugs thereunder. Moreover, as alleged, both the CSA and its related regulations set forth unique scheduling procedures for substances controlled under the conventions. Further supporting its denial of standing, the Ninth Circuit made a finding of fact in direct opposition to what I alleged. This directly conflicts with Twombly, which requires the court to accept as true all the factual allegations contained in the complaint. Specifically, the Ninth Circuit found that my injury would not be redressable because the conventions do not impose criminal penalties. This finding is untrue and contrary to my factual allegations for two reasons. First, I alleged in my complaint that respondents enforce criminal penalties for substances controlled under the conventions, and I am subject to that enforcement. As provided above, respondents enforce the criminal provisions of the CSA in the same manner, regardless of whether the substance was scheduled by the UN pursuant to the conventions or by respondents. In fact, many of the millions of arrests in the U.S. for simple possession over the past 55 years have been for substances scheduled by the UN pursuant to the conventions. Second, I allege a separate set of facts for my constitutional challenges to the conventions. Thus, should the CSA be found unconstitutional, that would not automatically extend to the conventions or Congress's implementation thereof, and could thereby leave my injury unredressed. By creating a new rule for treaty challenges and making a finding of fact contrary to what I alleged, the Ninth Circuit's ruling effectively made this significant piece of international criminal legislation untouchable and blocked me from challenging domestic law pursuant to which I am subject to criminal enforcement. The next section goes into how the Ninth Circuit made an insurmountable pleading standard. The U.S. Supreme Court upholds a liberal pleading standard and repeatedly warns against raising barriers that block well-founded constitutional claims before the chance for discovery. The rules provide all pleadings shall be construed as to do substantial justice, and no technical forms of pleading are required. A plaintiff must allege enough facts to state a claim to relief that is plausible on its face. Importantly, all reasonable inferences must be drawn in favor of the non-moving party, and all alleged facts must be accepted as true. So the next section is where I advocate that I stated claims that have merit for the First Amendment protections of freedom of thought. The prohibition of government abridgment of freedom of thought is among the strictest of First Amendment protections. Unlike abridgment of speech or expression, where this court permits limited exceptions, it has firmly stated that there is no justification that permits the government to enter the private, sacred, and intimate realm of unexpressed human thought and emotion to either create or use as a premise for criminal legislation. The barrier prohibiting such intrusion is absolute and impenetrable. This court has interpreted this prohibition in two distinct ways, both of which were alleged. First, on multiple occasions, this court has found that the First Amendment strictly prohibits any consideration, investigation, or probing into personal thoughts to create criminal legislation or otherwise deny freedoms, privileges, or benefits. Government actions counter thereto, regardless of any offered justification, are unconstitutional. And then I quote some cases that were beautiful and relevant. The first one is Spicer v. Randall. And the United States Supreme Court says in that case, what one thinks or believes has full protection of the First Amendment is only his actions the government may examine and penalize. The next one, Schneider v. Smith. The First Amendment's ban against Congress abridging freedom of speech creates a preserve where the views of the individual are made inviolate. And then Baird v. State Bar of Arizona. Whatever justification may be offered, a state may not inquire about a man's views or associations solely for the purpose of withholding a right or benefit because of what he believes. Accordingly, a plausible freedom of thought claim exists when one alleges 1. The government probes into our thoughts. 2. For purposes of creating criminal legislation. 3. In violation of the First Amendment's protection of freedom of thought. And 4. When such allegation is supported by sufficient facts. Here I stated a plausible claim for relief that respondents' actions are constitutionally prohibited and thus violate the First Amendment. Specifically, I set forth numerous facts alleging the following. 1. The government and UN created an entire investigation protocol to identify and predict thoughts, moods, desires, and emotions that might arise in individuals surrounding the consumption of a particular substance. 2. They have used and continue to use this investigation protocol for every drug evaluation under both the CSA and conventions. 3. The findings produced pursuant to these unlawful investigations are used to determine whether the private harmless conduct of possession will be criminalized. 4. These investigation protocols and findings serve as the primary and foundational basis for the resulting scheduling decisions and criminalization of private possession. It is further worth noting that in my complaint, I quoted direct statements that I found in government documents used to determine when personal possession of substances will be criminalized, wherein the government explicitly references specific thoughts, feelings, and desires it identifies as unfavorable for us. Such statements should never be found in documents relied upon to create criminal legislation, and their mere existence in government records should suffice to raise a plausible claim under the First Amendment. Alternately, the Supreme Court has interpreted the First Amendment's protection of freedom of thought to mean the government cannot constitutionally premise legislation on the desirability of controlling a person's private thoughts. In Stanley v. Georgia, reviewed by the United States Supreme Court, the government criminalized the mere possession of material the government deemed obscene in the express interest of protecting the consumer's mind. The Supreme Court found that this was an assertion that the government has the right to control the moral content of a person's thoughts. The court further found that the First Amendment rights include the rights to beliefs, thoughts, emotions, and sensations, and to be let alone and satisfy one's intellectual and emotional needs in the privacy of his own home. The Supreme Court held that the First Amendment prohibits criminalizing the mere private possession of material the government finds offensive, and that the government's power does not extend to possession in the privacy of one's own home. Accordingly, an additional freedom of thought claim exists when one alleges that the government makes the private conduct of possession of material or products a crime. It does so in the express interest of protecting, controlling, or otherwise preventing the contents of one's mind, and when such allegation is supported by sufficient facts. Here I stated an additional plausible claim for relief under the First Amendment. I alleged respondents criminalized the private conduct of mere possession of certain products for the explicit purpose of preventing and combating certain cognitive and emotional states it deems undesirable. This allegation was adequately supported by numerous objective facts. The government's primary purpose for criminalizing mere private possession of substances scheduled under the CSA and conventions is clear, explicit, and stated within the laws themselves: to prevent and combat the serious evil and immorality of drug abuse and its cognitive and emotional effects on individuals. Moreover, before this legislation was renamed to the Controlled Substances Act, it was named the Comprehensive Drug Abuse Prevention and Control Act of 1970. As described herein, drug abuse, which the government seeks to prevent and control, refers to cognitive and emotional states of individuals. I further allege that this unlawful purpose is evidenced through the drug evaluation process, which is primarily focused on investigating and predicting the personal thoughts, moods, and emotional states that could arise in individuals should they consume the substance under evaluation. Without any analysis whatsoever or reference to relevant Supreme Court precedent or the pleading standards, within just 2 mere sentences, the Ninth Circuit dismissed my freedom of thought claims wholesale. This was disheartening and shocking, as I never foresaw the possibility that such significant claims, supported by numerous facts derived from decades of records and direct government statements discussing specific thoughts and emotions it seeks to prevent, could be dismissed without any court analysis or any indication they were read or considered. The Ninth Circuit created an insurmountable pleading barrier that no claimant could possibly overcome. The denial of being heard in any meaningful manner is a significant injustice to us all, especially when the courts, who are bound to uphold the Constitution, often serve as our only avenue to prosecute unlawful government action and vindicate our most basic human rights. The next section is for the procedural due process claims. In my complaint, I allege that the drug evaluation and scheduling procedures of both the CSA and conventions result in the deprivation of multiple liberty rights, are inadequate and fundamentally unfair, and thus violate procedural due process requirements. The district court dismissed these claims after admitting it did not understand them, and the Ninth Circuit affirmed, stating that I had not alleged sufficient facts to support a finding of inadequate process. Again, the Ninth Circuit disregarded well-established law for pleading standards. At this stage, the court was not permitted to make the finding of fact of whether the processes are, in fact, adequate. Rather, it was only permitted to find whether I stated sufficient facts showing such claims plausible. The Ninth Circuit's finding directly conflicts with Twombly's plausibility standard and its requirements that the court accept my alleged facts as true and make any inferences in my favor. For procedural due process claims, I need only allege deprivation of a protected liberty interest through inadequate process and support such allegation with sufficient facts. As the determination of what process is due in any given situation tends to be case-specific, the courts consider elements such as the nature of the liberty at stake, the government function involved, and whether the deprivation would have occurred had due process been given. And where a statute imposes criminal penalties, the standard of certainty that due process requires is higher. In my complaint, I alleged over 80 paragraphs of facts, wherein 1, I thoroughly analyzed and described the procedures used by respondents and the UN. 2, I explained how the procedures were inadequate, biased, arbitrary, or otherwise fundamentally unfair. 3, I explicitly tied the inadequate procedures to the resulting deprivation of multiple protected liberty rights. And 4, I directly alleged that the drug schedules would look vastly different and the deprivations of liberty would not occur if fair and adequate process is used. Although there are too many inadequacies to list here, the most notable that I alleged include 1, a financial conflict of interest among decision makers, whereby respondents receive a direct financial benefit from their schedule, placement, and criminalization decisions. 2, respondents' explicit disregard for and statutory violations of the CSA's scheduling requirements. And 3, lack of any process to challenge the drug scheduling decisions that are made pursuant to the conventions and criminally enforced by respondents. Any of these 3 alone should suffice to allege a plausible claim of inadequate process, especially given that these processes result in criminal legislation responsible for mass imprisonment. The results of the unlawful government procedures are catastrophic and deadly. Prescription drugs are the 3rd leading cause of death in the U.S. behind heart disease, which is often caused by prescription drugs. When the government schedules pharmaceuticals as legal to be distributed and possessed, it falsely declares that these drugs are safe for use and less harmful than drugs on more restrictive schedules. As alleged, it makes such declarations while intentionally ignoring and omitting evidence that proves otherwise. These actions are to the direct detriment of the American people, who often trust that controlled FDA-approved drugs have been thoroughly analyzed for their safety and health benefits. Finally, the processes used here result in widespread deprivation of freedom and have remained unquestioned for decades. The Ninth Circuit's requirement that I allege more facts and prove my allegations beyond plausibility effectively created an insurmountable and unlawful pleading standard warranting Supreme Court review. Okay, now we are going to go into the second reason of why the United States Supreme Court should grant this petition. And to me, this is the most powerful section. This was the opportunity to express the voices of everyone who has been harmed. I love this part. This action comprehensively questions, for the first time in history, one of the most significant pieces of U.S. criminal legislation. As alleged with intricate detail in my complaint, the so-called war on drugs has inflicted an unprecedented amount of harm upon individuals and society alike. It is responsible for the mass drugging of the population with lethal, highly addictive, and toxic pharmaceuticals, and has caused the U.S. to become the world's leading incarcerator. Its devastation has impacted virtually every American household. For over 55 years, the CSA and conventions have gone largely unquestioned and unchecked. We became complacent and were programmed to blindly accept a system that insists a prescription label endorsed by the FDA and condoned by the DEA is the sole determinant of safety and well-being, and that those who step outside this commercial system are the true enemy and deserve to be punished. The government's method of punishing consumers under the CSA is unprecedented. No other law exists whereby the consumers of allegedly harmful products are punished, while manufacturers are not only protected, but are granted safe passage and security by the very government it funds. This system does not protect public health. It enforces compliant consumerism. It criminalizes the harmless conduct of simply holding in one's hand a product without a government-issued label. From where I stand, after extensive research and analysis, I see the government and pharmaceutical companies in bed together, with mutual seduction, each promising the other security, control, and profit through a collaboration designed to alter healthcare consumerism in their favor. The government entices Big Pharma with an exclusive legal market, guaranteeing the mass distribution of its drugs, along with a personal federal security force, ensuring consumers stay within this market or otherwise face life-altering punishment. In return, Big Pharma entices the government with a share of its profits, an entire population made malleable and submissive through products designed to numb the minds, emotions, and consciousness of consumers and create lifelong dependency. It is also critically important to consider why the First Amendment so strictly prohibits the government from investigating our thoughts and emotions for purposes of controlling or otherwise punishing us. When the government declares that certain thoughts, moods, desires, and emotions are bad for us, and then labels us as criminals for having such experiences, the effect on the human psyche and spirit is devastating. So many good humans walk around with their head held low, ashamed, and deemed by society as worthless, all because the government has told them and convinced others to agree that their intimate internal world is so bad that they deserve to be punished and removed from society. This legislation has created millions of criminals simply for how their minds work and how they privately experience their human existence. The upholding of these strict constitutional prohibitions is paramount to reviving the diminished spirit of the American people. Everything I stated in this petition and the pleadings preceding it is backed by extensive research and thorough analysis of government records properly cited in a well-pleaded and unprecedented complaint. Whether this devastating 55-year legislation has been enforced through unlawful or unconstitutional means must be questioned on behalf of all of us. Yet I have been denied the opportunity to even have my claims analyzed or be heard in any meaningful manner. If upon meaningful review the court determines there is no violation, so be it. But the right to question in the first place, to prosecute unlawful government conduct, is guaranteed. The beauty of our Constitution, specifically the Bill of Rights, is that it primarily serves as a declaration of prohibited government acts. And through Marbury versus Madison, the courts serve as the only avenue through which we, the people, can prosecute unlawful government actions. Thus, on behalf of those who have died, those who suffer still, and those who will if this continues unchecked, I stand as prosecutor of what might be one of the most dangerous, unlawful government conduct in our history. I'm not asking this court to create new rights or carve out new doctrines. I'm asking the court to uphold firmly established law protecting our most basic and fundamental human rights where the lower courts failed to do so. Thus, as my sole remaining avenue, I now kneel before this court with deep honor and respect for your role as guardians and protectors of the supreme law of the land and of its people, and pray that you recognize the historic and national importance of this matter and grant my petition. Thank you for listening. I truly hope you felt that. And if you did, and if you would like to share this with anybody, that would be greatly appreciated. Again, one of the reasons the lower courts have been able to just silence this and deny any form of justice is because we're quiet. No one really knows about this lawsuit, and a lot of people, as I mentioned, don't understand it. All it will take is just for one person who has a platform to get this out there. And the more people who understand it, who know about this, the more likely the Supreme Court will grant the petition, because they will know that we're watching. So this petition will be reviewed by the United States Supreme Court on September 29th, when they reconvene after the summer break. And on that date, they will either grant or deny the petition. If they deny this petition, all of this is done, and this unlawful government conduct and legislation will remain unquestioned. So I believe it's very important that we make this known. Thank you again so much for listening.